Today, let's talk about something we see almost every day but rarely stop to question. Those familiar signs in public places that read car parked at owner's risks. You will find them at shopping plazas, offices, event centers, hospitals, and even religious premises. On the surface, the message seems clear. If anything happens to your car, the property owner is not responsible. But legally, is it really that simple? While this disclaimer is commonly used by businesses to avoid liability for theft or damage, the law does not always accept it as face value. In many cases, where parking is paid for or where a property provides security, the responsibility does not automatically disappear. In fact, if damage or theft occurs due to negligence, poor security arrangement, or failure to take reasonable care, that disclaimer may not fully protect the property owner. So the real question becomes, when does parked at your own risk apply and when does it not? To help us understand the legal implications of this common practice, we reach out to Barrister Nasser, who shares his professional legal perspective on whether these disclaimers truly hold up under the law.
Wherever you see a sign, cars parked as owner at owner's risk, is an indication that the management of the place are giving you notice of disclaimer that in any eventuality, if you park your car here, you are on your own. We are not going to be held liable for any loss, damage arising from the parking, even if we provide security in the place. So basically, it's a disclaimer denying liability in any eventuality. Duty of care arises when there is obligation imposed on business partner. You see, like in schools, public places, shopping malls, hotels, there is a presumption that when you are going in, you are going in for a business purposes. Now, at what point can we say you have established relationship with the management of that hotels, shopping mall, supermarket, or any other commercial ventures? Is it at the point you entered and park your car that the law will presume that an obligation is created on the operators of that business to protect you or your property? Duty of care, in other words, it literally means obligation to provide care. Now, at what point can we say that obligation is created? And that is why the law is leveraged, is liberal in that. Because somebody can just come in, enter the place without doing any business. Like my office now, if there is a sign, you come in to do business, you didn't do business, and it happened that something happened to you. So how will the law enforce obligation on me when there is no any relationship that has been established? So that is why the law comes in order to limit liability on the business operators because business are run for profit. Generally, it relates to issue of negligence. And negligence has about four components. One of them is duty of care. And duty of care is an obligation to provide care, protection against damage. Now, when you enter any hotels, if they give you a tag, it's an acknowledgement that you are coming in. We acknowledge your presence and you are coming in for a purpose, especially when you paid for the parking. So it means a transaction has been entered into, and therefore obligation arises. So in situations like this, already a duty of care exists because by presenting you with the tag and accepting your payment is a presumption that you are going to park and we have issued you a ticket. And in the ticket, they will indicate the time you entered. If you spend 1 hour, there is amount you will pay. If you spend 2 hours, there is amount you will pay. The presumption is since they have accepted money from you, they have issued something to you, which only you can go out with it when you are exiting. It means there is a kind of obligation on them to provide you with the care. which is the protection of your personal belongings or properties. And at the same time, the second element is duty of care has been created by monetary exchange. You have issued me a tag, and I have also paid you for the services to be provided. Just like in Abuja, when it used to be the general practice where you park and pay. The general practice, before you even carry the car, when you park, they will give you a tag. Before you carry your car, you have to clear the bill. So in event something happened to your car, or somebody come and stole the car, the issue is, how did you allow this person to leave the premises without the payment? So the next thing is causation. The issue is three factors happen. Duty of care exists. There is a breach of that duty of care. There is causation. What is the causation here? Is the damage to your property. There is action, a malafide action by a third party, which ideally, if the person that issued that tag has exercised their duty of care, there wouldn't have been that damage. Then the cause of action arises, and you can legitimately pursue a claim and get a return in form of general damages or special damages for the loss of the items you suffered. So generally, if you want to sustain a successful claim against a company, a hotel, or any of the shopping malls where there is a disclaimer, the court always consider the existence of whether from the entire circumstance it can be said that a duty of care exists, and whether there is a breach of that duty of care, and whether as a result of that duty of care a damage is sustained as a result, before the court can arrive at a decision whether to award damage against the defaulting party or not.